why it's important, what it does for you, and what are the risks, especially for people with assets. So I typed in 580E at upsidedownrealestate.com in the search box, and you can see that I set up the statute. One of these should absolutely just be the statute, or maybe the statute and a few words afterwards. And then one of them I talk about how it's applied, and then I bring in some older ones. I've got posts from 2011 in here from the original upsidedownrealestate.com or my blogger posts. I've posted blogger from going back to 2007. That's how old upsidedownrealestate.com is. But I'll assume this is the right one. And I can see I already need to change the title on the spelling. ICIENCY, but we'll worry about that later. This is no deficiency. Well, let me pull it up. This will be there. Yeah, there we go. So let me, and I wonder if I can make it bigger. Yes, I can. Okay, so no deficiency shall be owed or collected, and no deficiency judgment shall be requested or rendered for any deficiency upon a note solely secured by deed of trust or mortgage. We have deeds of trust in California 99.something% of the time. Not more than 4 units. That's very important. Yeah, if you don't fit in the parameters of the statute, that's why it's on the internet. You should make sure you do, or talk to an attorney like me. I'm an attorney and a broker. Provided that both of the following have occurred. So this first A, I imagine, is saying they don't want you to be one of those people that were cheated or tricked or coerced into selling to a scam. And then secondly, the proceeds of the sale have been tendered to the mortgagee, beneficiary or agent. So that's the money is being sent to where the short sale negotiator advised escrow to send the money. Escrow should hopefully take care of that part of it. If you have a good escrow company with a good title company, I think that you can rest a little more assured. Now, this is an important one because you're going to be told by experienced realtors that you don't have to worry because it's against the law. I'm an attorney, and it is a problem sometimes, especially when it's like aggressive collection people. I can think of specific banks, and they're like, we're a federally chartered bank. We're not controlled by California law. And we want your person, especially seconds, we're doing this, to give us an extra $10,000. Otherwise, we're not doing the deal. And then like the first would have a problem with that being done on title. So then I was an attorney. I was like, well, we're going to have to negotiate a short. If my client even wanted to pay you some money, or I wanted to surrender some of my commissions, we'd have to first make sure we're not lying to the first. But secondly, we'll have to do it as a short pay because the first is only allowing $3,000 to go to you guys. They want the rest. So it's not going to happen. So that's the first issue. Sometimes they demand more than they can get, whether it's the first or the second, and they just don't care. And they don't care where it comes from. So you're going to have to work with a realtor who is flexible enough to protect you, shows you the risks. Are you violating laws? Are they? Does it matter? Do you want to get the deal done? Can you be protected? Can we put it in writing in the proper way? I'm just not going to let you send $8,000 to a debt servicing company or a debt collector, right? I mean, you have to be protected, but you want to get the deal done if you do. So this is an issue that arises in short sales. Even firsts from other states will say, I don't care. I want them to sign this note. And then you better have an attorney on your team. I would rarely allow my client to do that. I'd say, let's threaten to sue them. I don't know if we could sue them. Let's threaten to sue them for violating the law. You could do it now and we'll instantly file the lawsuit the next day. But I wouldn't recommend that. I'd say, let's just tell them that you're going to walk away, that you'll take the foreclosure. They'll get the property back 9 to 10 months from now. And there's going to be because you're already planning to move out. There's going to be an investor, a renter in there. They're going to be paying below market rent because it's a foreclosure, and you're never going to get an unlawful detainer on them or whatever. That's just one of the many strategies. Now, the next one, this is really important. The trustor or mortgager commits either fraud with respect to the sale of or waste with respect to. Over the years, not as much recently, but so many people that I would meet at kids' baseball games, or my kids are older now, but I remember so many people saying, oh, yeah, I did a short sale. Oh, I read your website. I talk to you on the phone sometimes. And they they're like, I was in the middle of a short sale. I called you. Two people that were realtors, parents who were realtors on my kids' teams said, yeah, we called you up. I had a few clients. You reviewed their paperwork. But it was this call that really was kind of interesting to me. It was like, yeah, and they might have been living in Rancho Santa Fe or Del Mar, or nice house in Poway. They're like, yeah, I did a short sale. How'd you get that done? You've got a pretty good job. Oh, well, my realtor just told me to fudge or lie. Well, I can say that I know that's part of the reason the zombie loans came about. People were collecting from these people. I don't want to give away client secrets, but do you really, after your property gets sold off to a collector or reviewed by, they frequently get reviewed or reviewed, and they sometimes control your initial application. They look at your initial app for the loan and they see if there's fraud relative to your short sale. I mean, people called me up and said that's what was happening to them. They did this with realtors, and they compared their packages. Like, so if you've got assets to protect, you just don't want a bank to know about. If you have reasons to be worried, if you don't want to show a hardship, if you don't want to lie about your assets, if you've got them, then really going to a realtor first is a mistake. You have other options. You can get, it's not a lot, it's harder. I wouldn't guarantee it, but you can do deed in lieu without showing your assets. You can sometimes do short sales if you gain enough leverage without showing your assets. In my other videos, I've sort of given away one or two of those strategies. I haven't really talked about the mechanisms, but the idea is that we're showing the servicer that they have a fiduciary duty to their investor to get this deal done now at this level, or they're going to be far worse, because we're going to use law every step of the way to protect you. They're going to be far worse when they get this property back over a year from now with renters in it, and they're going to have to do unlawful detainers and do cash for keys. And like, I'll send them requests that are strong under the law, where I ask for who their investor is so I can talk with them directly. We've got a lot of ways to get things done, but we have to be leveraging the law and positioning you in a way that we get some leverage over them. So this is the short sale law, 580E. Now the good news, no deficiency. So if the bank approves your short sale and you haven't committed fraud, and I would say, and you haven't done an approval letter that says to the contrary, then the bank shouldn't be able to go after you for what you owe them, for the difference between the loan and the amount they received. In fact, the law says that they will be considered paid in full. If I do not have the entire quote here, that will be changed. No deficiency shall be owed or collected, and no deficiency judgment shall be requested or rendered for any deficiency upon a note secured solely by the deed of trust. So it's not going to be owed, and it can't be collected, and no deficiency judgment shall be requested or rendered for any deficiency upon a note. So you can leverage this law. It's an excellent law. If it's done and executed properly, there's no deficiency. And because there's no deficiency, then it makes it a non-recourse loan in the eyes of the IRS. If you read the IRS circulars, I will, as a lawyer, I can't tell you there's no deficiency, but I can tell you I'd argue with the IRS. If you're working with us, I'll give you a letter and I'll even talk to the IRS. I'm not going to sue them, but they know the law. I can show you the package, the IRS forms that you'd fill out. I can explain it to you. You're going to go through and say there's no cancellation of debt income, even though you're going to get a 1099-C. But then we're going to have to walk you through the capital gains worksheet, see if you have capital gains. But I would say my understanding of the laws, and my understanding strong, is that because there's no deficiency, the IRS says that this would mean there's in fact, wait. I bet I have Barbara Boxer's letter here from back then. Is this it? From 2011? Come on, be it. No. There's a letter on this website from back then where there was an IRS letter in which Barbara Boxer, a senator at the time, asked him for a ruling. And IRS tax bill? Well, I'm not going to make you wait here with me any longer. I just know that there was a letter from the IRS to Senator Boxer on 580E. Well, maybe it wasn't 580E. Maybe that's not what. Maybe that's why it's not here. Let me read this and go to 580E and read the Barbara Boxer bill. Oh, that's a bummer. It must be a page, not a post. Oh, here it is. I don't know why I didn't see it before. I am responding to your letter dated August 28th, 2013. A short sale involves the sale of property for less than the outstanding mortgage loan balance. When an owner property enters in the short sale, the lender may hold the owner personally liable for the difference between the loan balance and the sale price. This is the nature of a recourse obligation. If the lender forgives the personal liability, the owner generally must include the forgiven amount. That's for the 1099-C. Congress has provided an exception that allows homeowners of cancellation of indebtedness income on their sale of principal residence to exclude canceled debt income if they are qualified principal residents. Then that's the Mortgage Debt Forgiveness Act. It just expired in December of 2025. On the other hand, if the property owner cannot be personally liable for the difference between the loan balance and the sale price, we would consider the obligation a non-recourse obligation. That's our scenario. In this situation, the owner would not treat the canceled debt as income. Instead, the owner must report the entire amount of non-recourse debt as an amount realized on the property. So no COD income, just capital gains. Capital gains might be all right. Again, this is from 10 years ago or more. Well, I know these things, but this is what I talk to people about. So they'd say, well, what about capital gains? And I go, well, the good news is with capital gains, every 2 years, a couple can write off $500,000 on the sale of a property. So if you've lived in it, this is coming back from memory, you better check my website. It's here. If you lived in the house for 2 of the last 5 years and you're a couple, you can write off $250 as an individual or $500 as a couple. That's just memory. I would absolutely check me, and I will go into capital gains taxes in the future, but I feel like that came out pretty clean, so that is most likely it. My name is John McConnon. UpsideDownRealEstate.com is the website. I believe that if you go to my strategy session, that UpsideDownRealEstate.com, and you're willing, I'm going to make this a little more detailed. Phil asked me to in my office because he's got 2 calls on short sales. But if you're willing to explain to us how many loans you have, what the amounts are, if you've refinanced, and if you don't want to do it on the net, we have other ways to get it done. But if you're willing to share, I don't want to waste my time, and I mean that's why I'm doing videos and give generalities. But I will, because I believe everybody should know the law when they're setting up their plan, and you should know how to leverage it. And I'm willing to do this for free while I come up to speed on what the market's like now. Are we dealing with a lot of zombie loans? Are people dealing with 2 loans? Is it just one? Have they refied some of it? So let's say they were at $500,000 loan and they paid it down to $400,000, and then they refinanced and went back up to $500,000. So they got $400,000 non-recourse, $100,000 recourse, and they want to know what to do. Like, I want to know those scenarios. So for now, we can do this for free. In the past, we started charging $300 to $500 for the recourse, non-recourse analysis. But for now, you go to strategy session at UpsideDownRealEstate.com, fill out this form, which will be a little more detailed, or call us, which you would get. I should probably put it up on this page, but you could call us, and there's the phone number, and we'll get that information from you and give you a good answer about what your options are. Thanks. My name is John McConnon. Talk to you later. Bye.